Okay, this will be my attempt, as I say, as an attempt to read this at 240 words per minute. I don't know how well I will do, but I will try. It's my first time. Ready? Let's begin. Ladies and gentlemen of the jury, at this time, prior to any summation, may I say first that I want to thank Judge Miller for his kindness and his courtesy. I have known Judge Miller and practiced before him for 15 years or more. He is one of our finest jurors. I have always respected him, and I have always known him to be fair and impartial. Any expression of respect I pay to him now is a reflection solely on the way I feel about it, because he cannot help me in this case. It is up to you, the jury. Judge Miller can only instruct you as to the law in the case. The defendant here before you now is guilty. He is as guilty as sin. He belongs in the penitentiary. I yield to no man in my respect to lawfulness, nor do I yield to any man in my abhorrence of violence. A violent crime has been committed, and this man belongs in the penitentiary. I am not here to try to pull the wool over your eyes. I am not here trying to or attempting to smooth out some incidents. That man is guilty of a crime. He is an accessory to the crime of robbery. Anything I say to you here about finding a verdict of not guilty, I want you to understand, and for that reason I want to put it to you plainly. This man is guilty of the crime of accessory after the fact of robbery. The penalty is the penitentiary, and that is where he belongs. So when I tell you now to return a verdict of not guilty, it is a verdict of not guilty with the indictment as a principle. You know Jackson did not testify to vindicate the law. Jackson did not testify to preserve the good order of society. You know that he did not do that. In every instance, his testimony was prompted by his honest desire to save himself from the long sentence that he richly deserves. However, if that testimony is not acted upon with the utmost caution, punishment may be taken away from the real culprit. I say to you, ladies and gentlemen, that you have listened to this case very intelligently. The state has given you its theory as to the guilt of the defendant. I have attempted to give you a theory that the defendant is innocent, which you are normally to believe. The judge will give you more instructions on that. Thank you, ladies and gentlemen, for your kind attention. And that was at 2:40.